tell you why it was that Mr. Barsh said what he said or didn't say. I will also tell Your Honor that when I talked to you, and in the presence of the prosecutor, I indicated that there was something in the range of $300,000 that might well be generated, assuming that the sale was made. On the other hand, what I do understand, and this is unique to companies, and I don't run companies, I just run my own little business. I'm a little lawyer out in Farmington Hills and just do that. A lot of these companies have what they call trade secrets and or other things, where they are not particularly interested in having certain workings of their company made public, and where when they have potential business that they don't want to have that broadcast, they don't want to have the business opportunity naming individuals broadcast or amounts of money broadcast, because that could have a deleterious impact on the actual sale itself. Because as we know, until deals are completely concluded and something has happened, a potential customer or client may change their mind, and they may find that if they're going to say things that then get broadcast to the public at large, that somehow they feel uncomfortable. Now, I don't know whether or not that's the reason that the Covisant Representative Mr. Bosch wrote it in the way that he did or not, but I am aware of the fact that there is that concern that the company has. And again, I can't speak to what Mr. Bosch said. I didn't speak to him, so I don't know that's why he wrote it, but I am aware of these other things. And certainly, I know that this court was interested in ensuring that Mr. Kilpatrick was not just simply seeking to have an absence from the court for reasons unrelated to his business, unrelated to the potential for making money that might be used for restitution. The court has legitimate reason to make sure that its own calendar proceeds expeditiously. I can't quarrel with that either. But I think that, you know, from that perspective, certainly Mr. Bosch did confirm that Mr. Kilpatrick had to be at this meeting, that it was business related, that it had to do with what he called, reading what you just read, an important sales opportunity for Covisant. And therefore, when you put it all together, it spells out that, in fact, Mr. Kilpatrick did have to go to this for reasons tied to his business, as opposed to for reasons that might be unrelated to business or unrelated to the possibility of making money which could be used for restitution. So while I agree with you that specific amounts are not put in here, identities of clients are not put in there, etc., I think that, as I said, these companies don't like to broadcast that for fear that it could jeopardize that sale. But I think that your basic concern is addressed, and you know, given the fact that these are, what should I say, unusual proceedings, because it's not that often we have proceedings like this. And Mr. Kilpatrick, of course, whatever he does, if it becomes a matter of public record, and this particular business does become a matter of public record, there's certain confidentiality that the businesses want to maintain. So I think that in terms of the legitimate concern which Your Honor certainly has, I think that that's been addressed. As for the rest of this, once these sales are made, and as I indicated to Your Honor, these are not the kind of things that are sold where sales are generated on a daily, weekly, or even monthly basis. It takes a long time for sales to be generated. These are products that are coming on the market. They're relatively new types of...
You're getting away from the issue at hand.
Well, I'm trying to...
Well, I know.
But
There's a double problem here. One is you don't work for them. You've already said this, so you're just speculating. But more importantly, your concern about whether the public would know, I made it perfectly clear no one was going to know. In fact, the prosecutor didn't even get a copy of this letter till today. And my concern was that it's highly unusual, as you know, Mr. Schwartz, to adjourn any court hearing for a defendant's schedule. We just don't do it. We're not concerned about defendant's schedules. When they have hearings in criminal matters and felony matters, this is a post-conviction hearing on a restitution matter, we don't really care about what the defendant's doing. I'm not talking about this defendant, any defendant in general. But because this is an unusual case and because there's so much at stake here, i.e. the restitution, your client indicated that he was going to make possibly $300,000 and that this could not be adjourned. So I asked that the letter be furnished to this court that it would not be divulged to anyone except me, because I needed to get that information. And this is the letter that I got. Now, I respectfully disagree with you that this answers the questions that I asked. And it's a concern of mine. Now, I haven't addressed your client, and I certainly could. I wanted to let you speak first. Perhaps your client wants to respond. He may not want to respond to this issue, but it is a concern of mine, and maybe Mr. Bach should testify for the prosecutor, for myself. And now that I didn't get the information, that's why I'm raising it. So I'm not here to argue about it because we may have to have another hearing regarding this. I'm just raising it right now because I did indicate that if in fact I didn't get the proper information, your client could be looking at a contempt hearing. That's why I'm bringing it up now. Now this is not a contempt hearing today, but certainly I'm not satisfied with this letter as to why we stopped this hearing. So I'm just telling you, I'm putting you on notice. Either you need to get more information or some explanation from your client, which again, I don't want to ask him about it because the whole idea was it was supposed to remain confidential with the court. And I'm not going to put your client in a position where he has to divulge a prospective client. What took place at that meeting, that's not for the public to know. I agree. But I need something more. So we can continue the hearing that we had before I brought this up. We can continue the restitution hearing. And we can deal with this. At the end of the day, you talk to your client on a break, figure out how you want to proceed at this point. And I'm not going to set a contempt hearing yet, but I may set one if nothing further comes to the court. I'm just raising it right now so you understand it, your client understands it, and I want to proceed with the hearing. And if that's okay with you, we can proceed with the hearing, deal with this later on.
Very well, Your Honor.
Okay, so let's get back to the restitution hearing at hand. And I believe Mr. Kilpatrick was on the stand and Ms. Sringas was still asking questions. Is that correct?
That is correct.
Mr. Kilpatrick, you could resume the witness stand. I'll remind you you're still under oath, sir. Ms. Sringas.
Thank you. Your Honor, before we start with continuing questioning, there were two exhibits that I moved the admission of last time we were in court, and Mr. Schwartz objected because it was not a certification. Is it related to Michigan First Credit Union? I do have that cert. I've marked it as People's Exhibit 64. I gave a copy to Mr. Schwartz. If I can approach, Your Honor, give a copy to the court.
Sure. Mr. Schwartz, have you seen it?
I have seen it. I saw it on the desk today. I've had an opportunity to read it.
And any objection to his admission?
Yes, Your Honor, because I don't really think that this is relevant. Whatever it is that Ms. Ramsey does or doesn't do with whatever money she's got is her business, and really I don't think is germane to the issues that are present.
All right, I'm going to overrule the objection. I think it is relevant, goes to weight on admissibility. The court's going to allow it. People's 64 will be admitted.
64, Your Honor, is the certification, and I would ask that, I think you could partially admit it, 47 and 48 is 3 pages, and now I ask that 47 and 48 be admitted in its entirety as previously marked and presented to the court.
Same objection, Mr. Schwartz?
Yes, Your
All
Honor.
right, same ruling, overruled. It goes to weight, not admissibility. It is relevant.